Sir, working with my junior, Mark Henderson, and the solicitors team from Howe Co, we take a firmly pro-family, pro-survivor and pro-community core participant stance. We will remind and emphasise this inquiry, where required, that the reason why the core participants we represent have been granted that status within the Inquiries Act 2005 is that the 65 that we represent are before this inquiry because they have lost loved ones. They have been injured. They have been poisoned by cyanide. They have been taken to hell itself. This means, and the driver therefore for our submissions, is that we ask this inquiry the simple question of when will it start? When will the truth come out? When can we start seeing the defences and potential excuses which will be raised by companies and institutions at fault? For the purposes of these submissions, we will refer to our written submissions and follow the same order. May I deal first of all, therefore, with statement taking from core participants and the giving of evidence before this inquiry set out at pages 2 to 4. We recognise that a real priority for this inquiry relates to the statement taking from core participants, and indeed a question that you need an answer to, which is when can that be completed? It is obvious to us that this is a major part of the process of getting this inquiry underway. Answering, therefore, the question of when the inquiry will start. And we know also that the inquiry needs to have these statements so that decisions can be made as to the measures that are going to be required in order for evidence to be given. These answers to those questions are of real importance to the inquiry, and they affect the basic planning of the inquiry itself, the length of evidence, the practical steps and technical needs that will be required from the giving of and the receipt of this evidence. Equally, we understand the questions asked in the draft guidance provided by counsel to the inquiry, though lengthy, are at least in part designed to provide answers for the experts who are considering the various parts of this disaster. Those experts need answers as far as possible, moment by moment, as to the spread of the fire, the so-called fire safety advice, and the way that the emergency services acted. Howe Co, my instructing solicitors, have some very real and recent experience in the statement taking from traumatised individuals. And we know that sometimes it can be a relatively straightforward task. But other times, sir, the grief and terror intrude so much that it can become a longer process. As has just been mentioned, people react different ways, and there is no right or wrong way. Equally, we have the very real practical problems of dealing with so many people still trying to bring a semblance of order to their lives. The answer that we have, and I hope helpful, is that we are starting the process of statement taking immediately, and we will not wait until all disclosure is complete. That has already been set out in correspondence from Mr. Howe on the 8th of December. Of course, we need disclosure. We need disclosure of the main parts, if not all, of the relevant evidence that can be provided from statements made and interviews that have been provided to the police. But that can be brought into those statements when it is made available. But it still does represent a need for that disclosure process to be completed as soon as possible, and we hope in January. We intend to take the statements as a whole and not leave out the part of the accounts to comply with any phasing of the inquiry analysis. The reason for this that we have considered is that the people we represent want to be heard, and they want their accounts to be given, and given in a way that deals not only with what happened in the lead up to the fire itself, but also the failures we suggest by the local authority and the state thereafter. The best way for statements such as this to be provided, we have found, is to allow the individual to provide their own narrative account of the incident, and then follow that with answers to the more detailed questions being asked through the inquiry guidance document. We would be assisted if counsel to the inquiry identify for the solicitors' teams carrying out this task the essential questions that are required by the experts. Now, that is because the current guidance on asking questions is some 200 questions and sub-questions, and the identification of those that are required by the experts sooner rather than later would be of real assistance. Further, it may be of assistance for the inquiry, and Chair, for you to consider that there is a need to have information from core participants who are providing statements as to how they would ask their evidence can be given before the inquiry, because that is a practical need that this inquiry needs to have answered. The very many courts that exist are very used to the different ways that evidence can be provided, from the witness box and in full view, from behind screens, over a video link with views limited to the chair and representatives, pre-recorded interviews, and sometimes, of course, anonymously. The question of survivor core participants, residents from the area or from those people most affected. Questions of those individuals may be requested to be asked by core participant legal teams. We ask that you deal with such requests with care. We suggest that such questions be indicated well in advance and over a longer period than may be required by institutional or corporate core participants. In summary, therefore, we propose the following. Statement taking to start immediately. Disclosure, as already discussed, being vital to complete this process and must be targeted to be complete as early as possible in January. We understand, of course, this may be phased, but the inquiry should not halt its disclosure process until complete, because we can read as we go through the disclosure in phases. And we'd also suggest that there is a date set by which at least an indication of which method or process for giving evidence will be likely to be required. And you'll forgive me for adding that perhaps the completely obvious. This is only an indication and should not be regarded as the final answer, because people's views may change. May I then move on to the core participant support points that have been raised already and we've set out in detail at page 5. For those giving evidence, there is a need to ensure that support is available. That can come in many forms. Trained counsellors, the presence of a friend or a relative, and of course, basic interpretation when required. But there is also a need for more general but equally vital support for those core participants who need practical assistance with childcare, transport and costs, whether they are giving evidence or not on any particular day. Travel, attendance and subsistence allowance and/or loss of earnings must be considered for attending hearings and meetings in relation to the inquiry, including meetings with solicitors. The provision of childcare at inquiry events, at inquiry days, the provision for the cost of that childcare to support meetings in relation to the inquiry, including, again, meetings with solicitors, support for regular, small, incidental expenses incurred by core participants, for example, the cost of printing, of documents that have been circulated, mobile phone credit to support contact with solicitors and, when necessary, the inquiry, access to computers and iPads or similar. Here, it would be wrong for me not to pause and thank the work of Rugby Portello, who have, I think, orchestrated and have been provided by companies such as Apple the handing out of many laptops and iPads and the like, not only to the bereaved, but to many others who have been affected. There is still, though, the need, as I was myself reminded this morning, to recognise that many core participants have lost all of their belongings, are still living in emergency or temporary accommodation, and have great difficulty in accessing the inquiry's website and receiving communication from the inquiry and their representatives. This is a real stumbling block, and we suggest it may well have been a shock to the inquiry team to learn how many core participants still live in single rooms in hotels, even to this date, and many will do so over the Christmas break. In terms of further practical arrangements, it has been set out in some written submissions that a 4-day sitting week of the public aspect of the inquiry might well assist in managing family responsibilities. It also is a practical way forward sometimes when dealing with large-scale inquiries or inquests to sit on 4 days, because the 5th day is either a useful day for the inquiry chair and team, but also, where necessary, if there is a need to deal with detailed legal submissions.
Well, I think there's pretty well unanimity on that question.
The inquiry site and its location has already been mentioned. We echo all of those submissions. It must be closer and must be closest to those people that have lost so much. The inquiry site must also allow for all faiths so that religious observance can be maintained, as well as providing a quiet space for those who simply need to get away and clear their heads. I turn now to the questioning of witnesses on behalf of core participants. We hope we can take this briefly, and we hope, helpfully, the trap that an inquiry can fall into is to overly limit the questioning of witnesses on behalf of core participants. This is an error. It engenders a feeling of exclusion and non-participation. Plus, frankly, it also leads to requests to hear submissions on these points, which actually tends to hold up the process. The preferred way is to simply limit further questions to new areas or new directions, and not to allow repetition from core participant representatives. Expert evidence and timetabling, page 7 of our submissions.
Yes.
As recently as the 30th of November, the inquiry requested that core participants make any submissions about inquiry expert witnesses no later than 4 p.m. on the 4th of December 2017. We submit that this type of timetabling of submissions and responses is wrong and devalued the participation within this inquiry of core participants. We submit this must never happen again. Doing this and accepting such timetabling, if we were to, would mean that the only dialogue that you will have will be only with lawyers, and it will become a chat between us and the inquiry, and it will lose the participation of core participants.
I think, to be fair to the inquiry team, they were intending to ask for immediate responses in time for this hearing. I don't think anybody contemplated that responses received later would be ignored. Make that clear, that's all.
It perhaps, may I temporise then for a moment, it perhaps should have been dealt with a little more care, because the correspondence did appear to give it as a final line. But may I assist? Mr Millett, Queen's Counsel, this morning accepted in his address that in fact later submissions would be welcome, and so we are grateful for that. But there's a further factor that is troubling, not only the short potential timeline to comment on inquiry experts. We're not at the moment informed of the basis, although it's been raised already, of the concerns raised by the Fire Brigade Union. Now, many core participants may wish to consider that. Submissions from core participants about matters of general concern, such as expert evidence, should be circulated to other core participants, so that there can in fact be an understanding and a dialogue amongst core participants as to requests that are being made. The second point we make about experts, and we note this morning this may have been accepted by Mr Millett, is that the bereaved, residents and survivor core participants should be allowed to engage their own experts, engage their own advisors, and be allowed the space, the time and opportunity to meet with them and go to the inquiry with expert reports that they've had time to consider and understand. It's obvious as we've seen already foreshadowed in submissions made by corporate core participants, that they have the resources and the ability to have recourse to their own expert assistance. So we suggest that it is made clear by the inquiry that this is an opportunity that will be given to core participants from the bloc and from surrounding areas. Of course, we don't make this submission without thinking about the consequences. This is not going to be, we suggest, an opportunity for every single legal team, every single firm of solicitors to engage their own experts. It is likely and probable that the inquiry would expect us to cooperate and act together in relation to joint instructions. That is obvious, but equally it is obvious that when doing so, that is in fact a time-consuming exercise. And the ability of 200 plus core participants, when they want to have access to experts and consider matters with them, is something that will take planning. And so, again, going back to questions that have already been foreshadowed about disclosure, the sooner we have expert reports that can be considered, the better. May I then move on, please, to deal with disclosure rather more pointedly. This has already been dealt with largely by Mr. Weatherby. This is at page 9 of our written submissions.
Yes.
We strongly support the proposal that public and corporate core participants be required to file a statement of their position, including any failing that they accept on their own part, and that they must be guided by a duty of candour in what they say. Now, to an extent, the duty of candour is a legal phrase that has been used in relation to judicial reviews, but the guidance on this applies equally to inquiries and inquests. The duty of candour is relevant in a second respect to the adequacy of the disclosure exercise. For public authority core participants, we urge their adherence to the guidance on discharging the duty of candour and disclosure that has been set out at 2010 by the Treasury Solicitor. And that was published to address concerns about the inadequate appreciation of candour and disclosure duties by government departments when dealing with judicial reviews. This document, published in 2010, states that the guidance may also be relevant, as we've said already, to inquests and inquiries. The failure of public authorities to appreciate the extent of their duties to make reasonable searches and how to go about them is a long-running problem. If I may just very briefly quote from that document. A public authority's objective must not be to win the litigation at all costs, but to assist the court, in this case an inquiry, in reaching the correct result, and thereby to improve standards in public administration. We ask that not be forgotten. But lawyers for institutional and commercial core participants must be reminded of their own fundamental duty to ensure that their clients preserve documents and make adequate disclosure searches. We have emphasised the broad approach to relevancy of documents that is required also as part of the restoration of public confidence, and that in fact is a wider test than standard disclosure under the CPR, the Civil Procedural Rules. Public confidence will also be assisted by the victim and survivor core participants having a proper opportunity to engage in the disclosure process. We have observed in our written submissions at paragraph 29 that we have yet to see the original disclosure requests, despite the inquiry having confirmed that sight of these might not be problematic. We understand this is a matter of some debate at the moment. We will appreciate that the inquiry does not wish to engage in matters which procedurally will lengthen the process. But it is possible, no doubt because the inquiry itself is keeping a record in some form of schedule or chart form, to potentially have access to those inquiries and questions that have been raised so far, so that gaps that we identify can be identified and filled. So we look forward to a discussion with the counsel to inquiry and solicitors to the inquiry, so that we can consider the best way to approach that particular problem. But as matters stand, the court participants we represent have been unable to review the scope of disclosure sought from the public authority and corporate court participants. And therefore, as things stand, we've been unable to make any effective submissions on it. And that, we suggest, is not right. We also agree that it is vital that all court participants are required to make a proper disclosure statement, explaining how they have secured the preservation of documents, how they have conducted their searches, and how they have satisfied themselves that they have complied in full with their duties. Now, this is not just a formality. It serves a vital role in holding them to account and in enabling fair and meaningful engagement from the victim and survivor court participants in the disclosure process. And so Mr. Millett has already said this, and we agree with him, that in practical terms there should be a meeting between representatives to deal with those sorts of issues. Practical matters in relation to disclosure include the question of what system is going to be used. It may well be that this inquiry will use the relativity system that is of assistance in relation to an inquiry that we're already part of, working with Howe Co. That is the child sexual abuse inquiry. We have learnt through using that system that there are some issues that need to be grasped. Training in its use is welcome. Care needs to be had in terms of loading non-searchable documents. And there is a definite need for indexing to be completed with care and so that it can be employed properly. The inquiry panel and diversity of membership, page 11 of our submissions. This has been addressed already. We support the principle that the inquiry should in fact incorporate individuals with a background that is more representative of the community. But there are additional ways, not instead, but additional ways to involve victims and survivors in this inquiry, examples of which are currently being used in the child sexual abuse inquiry. This includes a rolling programme of open seminars facilitated and attended by counsel and solicitors to the inquiry. Now, this has been successful as part of that inquiry process. It allows open and robust discussion and debate to be had between court participants and the inquiry. It goes further than simply acting as a discussion group, because it allows the seminars allow themselves, and people that attend it, to be used as a test bed for suggestions and indeed potential recommendations. Let me make this simple point that probably is now obvious to you, sir. The community and the tenants are the experts in being the service users. They are also the people who lost their lives when those services went wrong. They deserve the dignity of being able to discuss and appropriately inform this inquiry. Now, you've already mentioned, when discussing matters with Mr. Mansfield, that the inquiry could consider the employment of a victim and survivor consultative panel. This is a method of engaging people with an inquiry that is used by the child sexual abuse inquiry. It works. It is a layered approach to engaging with the community and with core participants, so that you don't just have a survivor and consultative, victim and survivor consultative panel, you have seminars as well. The consultative panel, the way it works normally, is allowed a day or week, or a day every 2 weeks or something similar, to consider the practical steps that are currently being taken by the inquiry and what further suggestions would help you. The seminars allow for people to engage with the ongoing work of the inquiry and feed their ideas, not their decisions, again to you. That then brings me to decision-making and recommendations. This has been addressed variously in terms of the phasing suggestion that is being made by the inquiry. The choice of what is or is not included within any phased or module aspect of this inquiry is a matter that we will address further in writing. But as an example, the stay put advice is a matter that we respectfully submit should very much be part of phase 1, if that is what you do, sir. But all of your work, all of our work, will be lost in a library, slowly gathering dust, if it is not accompanied by attention given to implementation and oversight of change. This means report yes, where required. Come to interim decisions, yes, where required. Recognise when change must occur, yes, where required. But do not let this go quietly into the good night. What you must do, sir, is make sure that change is carried through where required. The danger being, essentially, that the inquiry closes without there being oversight. And so, please, sir, when you are getting to the stage of considering any recommendation, one of the advantages of doing so within the life of the inquiry is that you also oversee change and implementation. And that is a matter that can be considered during the ongoing work of the inquiry. So, no doubt, by now, you will be more acutely aware than anyone else that the reason why you have been appointed to chair this inquiry is so that you can examine potentially the failures in the work of others. This may be the most difficult work that you and Council of Inquiry have ever undertaken. Much of what will be before you will be unfamiliar, as you will be having to consider the many areas that are within the remit of this inquiry and not be afraid to turn over the rocks and see what horrors lurk underneath. I return to my main theme, which is do not make the mistake of discounting the work and contribution that core participants can make to this inquiry. It is a mistake to say that they are simply witnesses. They are not. The core participants we represent will not just bear witness to the circumstances leading up to and surrounding the fire at Grenfell Tower on the 14th of June 2017. Those core participants also have opinions about how matters can be handled in the future and their ability to be heard on safety matters, about relationship with the local authority, and, of course, about the way that fire safety can be delivered in the future will be vital to this inquiry's success. The core participants we represent have a voice and have opinions that are valuable to you. Listen to them and please don't reject them. So if you do this, and your inquiry team are seen to be getting to the truth with bravery and conviction, you will have support. But, already spoken of by others, the gaining of trust from survivors of a tragedy of this magnitude, where people's lives have been broken and ruined by the very state that appointed you, is not easy, and it will take time. So those are our submissions. Can I assist me, Colonel?
Mr. Stein, thank you very much indeed. They're very powerful and helpful submissions. Thank you very much.